All right, good evening. What up, everybody? Welcome to the channel. If you're new, don't be. Go ahead and click that subscribe button to be a part of the Witness gang, to join the Witness Nation. Let's get into this, shall we?
They doing it You made it in court. Mind you, she's done porn. She's in the process of still doing porn, meaning she did it.
Well, first off, I want to say that y'all got to understand that fame is a hell of a drug. Welcome back, everybody. Good evening. Okay, it's 10:54 p.m. Central Standard Time here in the lovely nights of Texas. Okay, I am reporting to you live from my Facebook because as of right now, my main channel is down until next week. But let's go ahead and get into what we're here for. Okay. All right, so just to get everybody abreast and afloat as to what is going on, we are about to hear the response from the government for Bonjean's latest submission of a reconsideration for the sentencing to be pushed back. She placed in for it to be pushed back till after his sentence, which is August 1st. And so it got denied. And so it got pushed just a month later to June 16th. She submitted for it to be reconsidered again for the same date. And so just the other day, she stated that she received it. And now we are hearing the government's response because upon Judge Donnelly receiving it, she stated that she's going to allow the government to respond. So here it is, you guys. Okay, so let me go ahead and share my screen. And let's go ahead and see what the government had to say. I didn't even do my whole spew, child. I'm going to do it at the end. Okay, well, let's go ahead and get into it. All right. Okay, let me share my screen. And if you guys please could share this video. All right. And it's only 4 pages, baby. They went straight to it. Okay. All right. Let me remove myself from the screen. Okay. All right. Goes on to say, Dear Judge Donnelly, the government respectfully submits this letter in opposition to the defendant's April 5th, 2022 motion for reconsideration of the court's order denying in part the defendant's motion to adjourn his sentencing. Okay. Goes on to say specifically, the court denied the defense motion to adjourn his sentencing to a date after his trial in the Northern District, Illinois. Pursuant to the court's April 5th, 2022 electronic order, the defendant is currently scheduled to be sentenced on June 16, 2022 at 10:30 a.m., more than 8.5 months after the jury found the defendant guilty on all counts. Reconsideration of the court's decision is not warranted. First, proceeding with the defendant's sentencing prior to his NDIL trial does not violate the defendant's Fifth Amendment rights. The Fifth Amendment provides in relevant part that no person shall be compelled in any criminal case to be a witness against himself. As the Supreme Court has long held, this prohibition not only permits a person to refuse to testify against himself at a criminal trial in which he is a defendant, but also privileges him not to answer official questions, but to him put to him in any other court proceeding, civil or criminal, formal or informal, where the answers might incriminate him in future criminal proceedings. This particular case law, Minnesota versus Murphy. Okay, the potential statements at issue here involve the defendant's provision of information to a private mitigation expert hired by his defense counsel. Whatever information the private mitigation specialist would potentially provide to the court would not be based on any compelled statements of the defendant. Indeed, the defendant is not being compelled to say anything he is potentially choosing to do so. That is, of course, his choice. But while the Fifth Amendment shields a defendant from the consequences of his compelled statements, it is not a sworn that allows the defendant to benefit from a voluntary choice to make statements without any conceivable risk. Indeed, this choice is faced by all convicted defendants. He ain't special, basically, when they decide whether and to what and whether and to what extent to provide information to a probation officer preparing their president's um, I'm sorry, pre-sentence investigation report regarding the offenses of conviction, particularly those like the defendant convicted after trial who intend to file an appeal. As the court in United States versus Davis observed in denying a defendant request that he be permitted to make statements to the probation department and to the court in connection with sentencing without having such statements used except in the sentence proceedings in order to preserve his right to a meaningful appeal. The defendant exercises his Fifth Amendment right at the trial and declined to testify. He is still entitled to the Fifth Amendment privilege at the time of sentencing and can decline to make any statement. On the other hand, the defendant is entitled to speak on his own behalf in connection with the sentencing. He is entitled to address any comments to the probation department and to the court, which he believes will assist him. If the defendant chooses to speak, and if he should make admission of guilt or should make false statements, certain consequences may follow. There is no bias for the court to insulate him from such consequences. Okay, and that's the case law in which they're referring to. The Fifth Amendment protects defendants only from compelled self-incrimination. Even accepting the defendant's argument that his fear of self-incrimination removed and true ability to exercise the choice of allocution. Thus, the defendant's reliance on R1 versus Ennis, this particular case law, there the Supreme Court held that Miranda safeguards come into play whenever a person in custody is subjected to either express questioning or its functional equivalent, and explained that interrogation under Miranda refers not only to express questioning, but also to any words or actions on the part of police, other than those normally attended to arrest and custody. Now, the police should know are reasonably likely to elect. I think it's elix. Okay, y'all see it. And in incriminating response. Okay, this particular case law in it. Okay. In noting that by incriminating response, we refer to any response, whether inculpatory or exculpatory, that the prosecution may seek to introduce at trial. Okay, this particular case law ID at 301 in 5, the Supreme Court was clearly referring to custodial questioning by police. Wow. Here, the questioning at issue is neither custodial or conducted by law enforcement. Bonjean tried to use a different case law that had nothing to do with what is going on here. Okay. It is voluntary questioning by a defense paid mitigation specialist, which the defendant can decide to use at sentencing or not, and raises none of the Fifth Amendment issues the Miranda rule was designed to address. Sentencing, we do not find that such a constraint rises to the level of compulsion required by the Fifth Amendment. United States versus De La Paz, this particular case law, affirming district court's refusal to grant a continuance of sentencing where defendant following his guilty plea to firearms offenses requests a continuance because he could not adequately exercise his right of alcohol. Y'all seen? I'm sorry, I'm butchered that word. Because an indictment for a continuing criminal enterprise was pending against him, and the information he wished to mitigate his sentence for the firearms violation might be used against him in the pending trial. Notably, the defendants expressed concern. Here is even further removed. Statements made to a mitigation specialist retained by the defense are inherently less risky in this regard than statements made to a probation officer during a pre-sentence interview or to the court at the sentencing proceeding. Defense counsel will undoubtedly have the opportunity to discuss any statements made by the defendant to the mitigation specialist with the specialist prior to any disclosure to the court, and will be able to review any report prepared by the specialist prior to making a decision to submit any or all of the report to the court. Moreover, as noted in the government's response to the defendant's original motion to adjourn sentencing, the same alleged concern about future use of potentially incriminating statements made to a mitigation specialist exists even when only considering the defendant's case in the district, as such information could affect that defendant's appeal and any new trial sought by the defendant on appeal. This particular case law, again, given that the same pertinent purported concern would exist even after the NDIL trial, the existence of the NDIL trial cannot serve as a valid basis to delay the defendant's sentencing. Notwithstanding that the defendant's concern does not provide a valid basis to delay his sentencing, the government nonetheless proposed a procedure that would address and alleviate those concerns, namely allowing the defendant to file any mitigation report or relevant portions of it under seal and issuing an order prohibiting the government from disclosing the report to anyone involved in the NDIL prosecution. The defendant simply asserts without any discussion that the proposal does not sufficiently protect defendant's Fifth Amendment rights. As discussed above, however, proceeding with the defendant's sentencing does not violate the defendant's Fifth Amendment rights, and the defendant's bald assertion to the contrary is not a sufficient basis to delay his sentencing, particularly whereas here there is a way to ensure that any potentially incriminating mitigation statements made by the defendant that he wishes the last page, you guys, court to consider as sentencing can be provided to the court without risk that such statements will be used by the prosecution in NDIL. Finally, the defendant's ask is not a small one. Whether the defendant likes it or not, his accusers are victims of serious crimes and have rights under the law. Those victims have the right to be reasonably heard at any public proceeding in the district court involving sentencing, and the right to proceedings free from unreasonable delay. And furthermore, were the court to grant the defendant's request, the government anticipates that the defendant will make additional requests to delay the defendant's sentencing on precisely the same legally baseless ground. Given that the defendant also faces criminal charges in state court in Illinois and Minnesota, moreover, the court cannot predict whether an unforeseen development in the NDIL case will delay the trial there for an unknown period of time, requiring the defendant's sentencing to occur after the NDIL trial and any other as yet unscheduled trials in the defendant's pending state cases to address the defendant's purported Fifth Amendment concern. It's simply not reasonable in these circumstances. Respectfully submitted, the United States Attorney. Well, there you have it, you guys. They are literally standing 10 toes down when it comes to their response. Hey, Dory. Hey, you guys. Welcome from Facebook. Yes, I'm going to explain that real quick. Hey, Melody. Hey, is it Bina? Hey, Bina Weena. Hey, you guys. Okay, so real quick, since we're finished with that, what is going on with my channel is that it's down right now. I have a backup channel. It's not quite ready for me to be able to go live, but it is Whitney DTV 2.0. If you guys will do me a solid and go head on over to the channel and subscribe to it. So in cases like this, I'm able to still keep the ball rolling for you, which it clearly didn't stop anything. You guys were able to tune in here. But yes, my channel is down until next week due to some kind of violation. But that's neither here nor there. I just wanted to take out the time to actually read the docket in its entirety. Okay, so yeah. So basically the government is saying, no, we won't go. We're not about to prolong this situation any further. Hey, Melody says, thanks, Miss Whitney, for sharing with us. We appreciate you. I appreciate y'all for hanging in there with me and listening in. I tried to stay up as long as I could. Y'all took a whole nap, okay? I was like, and it still ain't here. So I told my husband, I said, I hope it's okay if I stay up a little bit. And so technically they got it right before midnight. It's 11 p.m. here in Texas. So on the East Coast, I'm thinking it's what 12:10 there. So they got in, y'all, right in the skinny and the cusp of it, but they got it in. And so, like I say on Whitney D TV, when I'm doing these R.Kelly tales and on such, Judge Donnelly works fast. We are going to get a response from Judge Donnelly, I promise you, tomorrow. You heard it here first. I'm serious about it. I haven't been wrong when it comes to Judge Donnelly. If it's not a holiday, she responds within 8 to 24 hours. If it's a weekend or something like that, I give it 32 to 48 hours. But for the most part, Judge Donnelly is quick. She gets it done. She responds very swiftly and quickly. So we will get a response in regards to it. I pray to God she doesn't allow the defense to respond because this is it's just like patty cake, just going back and forth. So, basically, in a nutshell, they're basically saying, as the government is saying, look, we've already addressed this. Okay. While Bonjangles is over there being a Twitter thug, okay, and thumping them fingers, she should have just did a due diligence of thumping her fingers through the 5,000 documents of transcripts on the original trial. It's not the government fault that you need a little more time, because this is what she's doing. It's all strategic. She's trying to push this back to get herself more informed of what's going on. Okay, because technically, you guys, we're really in the thick of it where we can really hear back from Judge Donnelly in regards to the ruling of the appeal. It's done. If you guys notice, we haven't heard anything in regards to Judge Donnelly saying, okay, now we need to have the government respond. I really believe that is it. with the whole appeal. And with this response, I think it's done with them trying to continue the freaking sentencing. But I don't know, you guys. I just go off of just common sense and looking at the docket and things to that nature. I didn't see any with her stating with the last response from Bonjangles or whatever on the defense team saying, hey, now I received it. Now the government, it was nothing like that. It was just received. And then she responded for the defense, for the government to be able to respond to the sentence. She didn't say anything in regards to the government can respond to Bojangles. So I think it's it, you guys. So I think we'll actually be able to hear something in regards to the appeal here soon, because there's no pending dates. And now it's really done, because today is the 7th, and the government got their response in, and we heard it. So those that are coming in, I'm not going to let this video go long, so if you guys want to run it back, so the government, baby, they are not playing. Bonjangles can be on Twitter and keep thumping them fingers all she wants, and keep missing the boat all she wants, shall. Melanie says, right, she needs to stay off of Twitter. However, they're seriously clowning her on there. They really are. They really are, because like I was saying on my channel, like they up here having her put on this cape and stuff like that, but we see through that. And a lot of people see through that. Girl, you all, taking the black man down. That's not true, baby. This done happened to other white men. The dude that was over the Nexus situation. You know what I'm saying? Keith Rayner and Onslaught. Girl, stop it. Stop it. But see, you know what she does? Very smart. She been on YouTube, okay? And she's appealing to those people that are trying to take the black man down. No, he took himself down, baby. And shoot, he don't represent us. Heck no. Take him, baby. Take him. Take him. No, 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 no. Tomato, tomato, tomato. Boo. We don't want him. We don't want him. He don't represent our community. They're clowning her on Twitter. They are. They are. And I just really feel like she just needs to leave it alone. Girl, stop. What are you talking about? And the cool thing about it, no shade, no tea, is white people. It's white people clowning her. It's not us. It's white people like, girl, stop. Okay. If the black people don't see through you on this side, we see through you. Okay. We know what you about. You know what I'm saying? And baby, she is talking all that chink and chong over there. She is upset. I should expect this from the media that's been sucked up. Girls like, yeah, Bob. Yes, for real. Yeah, Dory posted it. If you are not, y'all, please, 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 if you guys are just tuning in here on my channel, head over to the R.Kelly case open discussion group here on Facebook, y'all. And if you're tuning in from Twitter, because I know I got some of my Twitter viewers and my Twitch, head over to the R.Kelly case open discussion group on Facebook, y'all. They are so on it in regards to this case and this trial, and they keep an update when it comes to this case. And Dory, oh my God, her silly self, she's been keeping us abreast what's going on in Twitter world when it comes to Judge John Lee. So yes, you guys. Let me see. Melanie says yes, her own people best part. Ain't it funny how, and I just want to, y'all know I'll get deep. Ain't it funny how white people don't have a problem about holding their people accountable? Just like Weinstein. We don't hear nothing else about it, do we? They said, all right, it's done. They got their money. This is that and the third. But us Negroes, oh no, don't take the black man down. He ain't a pivotal part in this community. He made good music, y'all. But he abused and neglected a lot of our black girls and boys that they don't want to talk about. Okay. So no, we don't want representations of like that. I don't even care too much for Bill Cosby. Child, what you mean? You're not a reflection of the good men and women that we have in our community that we stifle because we don't like the truth. We don't like goodness. We don't feel like we're worthy of having good representation because we have bad representations in our family. Okay, we're going to talk about it. No, we're not because it's too late. But I'm just saying, you got Ray that you know that sit at the dining table at all the family functions and dinners, and you know he touching the kids of the family, but you overlook it. It's no different. You guys identify so much with R.Kelly because you got him in your family. Ooh. So yeah, you wouldn't turn your cousin in, right? I would. I don't give a darn, if it was up to me. But yeah, you weren't turning your brother, your daddy, and all that because it's familiarity there is, so that's the reason why, if we get deep with it, that's the reason why they don't want to see R.Kelly down, because they can identify with the sickness of what he pumps into the community. Like, seriously, what do he contribute to the community? Chicago don't even like him. Like, let's be clear. Chicagoans knew this man was doing this. Okay, knew he was doing this. And they were like, we couldn't really do anything because, he had the whole city strapped up. But I think now Chicago has a voice now, and they're tired of it. They're no longer going to hide him and support him anymore. So Illinois is about to get real raggedy. And that's why the people are still holding on to New York. It's done, y'all. He's been convicted. He's not getting this appeal. And they can push and play with this sentencing all they want. They are prolonging the inevitable. Okay. But not for nothing, you guys. That is the video. I love y'all so very much. I'll be back up and running on my main channel of WhitneyD TV. In the meantime, I pray that you guys can head over to my second channel and go show me some love. Go subscribe to my channel. It's called WhitneyD TV 2.0. Literally type in WhitneyD TV 2.0 and it'll take you to my channel. Okay. Well, like we end all of the R.Kelly tales. You're killing me with this.
Y'all killing me with this. I can't help. I can't.
Robert.
I can't help. You're killing me, man. This ain't not about music. I'm trying to have a relationship with my kids, and I can't do it. Y'all just don't want to believe the truth. You don't want to believe it.
At this point, we briefly pause the interview to give Kelly a moment.
Man, y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me. Y'all trying to kill me. Y'all killing me with this. Y'all killing me with this. Y'all killing me with this. Y'all killing me with killing me, man. Trying to kill me. Killing me, man. Trying to kill me. You don't want to believe it. Trying to kill me. Killing me, man. Trying to kill me. I hope this camera keep going. Stupid R.Kelly. Fight for my life. Stupid R.Kelly. Do it. Stupid R.Kelly. Fight for my life. Stupid R.Kelly. Do it.
You made it in court. Mind you, she's done porn. She's in the process of still doing porn, meaning she did it.
Well, first off, I want to say that y'all got to understand that fame is a hell of a drug.